Good morning, Chair Postman, Member Garrett, staff and guests. The lobbies are open and the recording has begun.
Thank you, Justin. Good morning, everybody. We'll convene the Washington State Liquor and Cannabis Board meeting for Wednesday, December 6, 2023. Member Vollendorf is out ill today. Our first item on the agenda is a fun one. We were going to recognize an employee of 30 years, and I will turn it over to Jeannie McShane from licensing.
Good morning, Chair Postman and Board Member Garrett. For the record, my name is Jeannie McShane. I'm the Deputy Director of Licensing for the Liquor and Cannabis Board. It is my honor and pleasure to be here today to celebrate Marcy Wilsey's 30 years of state service. Marcy, you want to come join me while I say nice things about you? So just wanted to put some things into context for you. Remember 1993? Whitney Houston's "I Will Always Love You" was #1 on the charts, the longest #1 single in history. The #2 song that year was the rollicking "Whoop, There It Is" by Tag Team. 1993 was also the year that Sleepless in Seattle, The Nightmare Before Christmas, Jurassic Park, and Mrs. Doubtfire were showing in theaters. Movie tickets were a whopping $4.14 on average across the nation. A gallon of gas cost $1.16, and milk was $2.86 a gallon. Bill Clinton started his first term as president, and Janet Reno became the first female Attorney General of the United States. Another historic milestone was Marcy Wilsey became a permanent staff at the LCB. She had worked for us previous, but was not permanent at that time, so she actually has much more than 30 years in service to us. It is my absolute pleasure, as I mentioned before, to give Marcy this award for her 30 years of service. All of her time with the state has been with the LCB licensing division. She has witnessed and been a part of a lot of change in that time. As I listened to Marcy talk about her years with the board, the 2010s were the most impactful. They brought significant historical changes to the board, and Marcy has helped shape many of those. She was here to help the board enact Initiative 1183, which privatized liquor sales. She also shared her experience with liquor licensing when cannabis was legalized, and the team was creating the first ever legal cannabis system in the country. She helped develop the Oracle system to support cannabis applicants, and today she's bringing all of that history with her as she works with our partners to integrate our systems into our new computer system. We're lucky to have someone with so much experience with our work on the systems modernization project. Marcy's understanding of where we have been over the last 30 years has been invaluable to the process. Imagine that when Marcy first started, our current system, the AS400, was only a few years old.
I was only 12.
Yeah. She's a very young woman at that time. I asked some of our colleagues to share their thoughts about Marcy. Deputy Chief Ranke said, I've been with the LCB since 1997 and have always found Marcy to be extremely helpful and friendly. If she is asked questions, she will always find the answers and get back to us quickly. Marcy has been a true asset to the licensing division and the agency. Captain Tom Dixon, who's also been with the agency for 30 years, we celebrated him a few months ago, said, in addition to being a great interdivisional team player, Marcy has a great deal of institutional knowledge and is one of my go-to persons for historical knowledge. Over the years, Marcy has been able to answer many of the whys of our old processes. She's also just plain nice to interact with. I couldn't agree more with Captain Tom. Marcy is a wealth of information. She's a great team player, and she always is open to discuss the question, how the heck did we get here? Marcy's previous supervisor, John Engelman, said, I'm lucky to have had the chance to work with Marcy during her time as a supervisor from 2019 to 2021. Marcy was a fantastic team member, and I relied on her many times to sort out thorny licensing issues. She brought a lot of wisdom, humor, and patience to the liquor licensing super team. It was a pleasure to both get to know and work with Marcy. She truly does bring her best. So please join me today in celebrating the one, the only, Marcy Wilsey, as she passes this impressive 30-year milestone.
Congratulations. Marcy, congratulations, but also apologies that we still have the same computer system we had when you started. All those things Jeannie mentioned are long gone, you know, from 1993, except for that. So
and I will be happy to see it be part of seeing it go.
Yes, and thank you for the work on SMP because that's a big, big, big one. So much appreciation from the board, and it's always so great to find people in this agency who've been here that long. There's something about this place. People are dedicated, so we really appreciate that history. Thank you for it all.
Thank you.
Great, thank you, Jeannie. Okay, we now have a action item. The board is going to consider a proposed memorandum of agreement between the LCB and the Stillaguamish Tribe of Indians. And I'll ask Dr. Marla Conwell, our tribal and government liaison, to come up and present that to us, and then we'll take a motion for adoption. Good morning.
Good morning, board. Good morning, Member Garrett. Happy to be here and present the MOA for consideration. It's with the Stillaguamish Tribe of Indians. We completed negotiations earlier this month, and I have assigned authorization form and approval from the Stillaguamish Tribe signed by the chairman, Eric White. And I also have a copy of the MOA here as well. Do you have any questions?
That's great. Can you just give us a quick summary of why we're doing this now and what it'll do?
Sure. Prior to now, the Stillaguamish have had several liquor licenses with their casino and several enterprises, including a couple of convenience stores. They would like an umbrella MOA to pull all of their licenses together and work on eventually making some other changes as well. And so that's what we have brought together.
Great. Any questions from the board on this?
No questions.
Okay. Yeah, so I'll just say I had the chance to work on this a little bit with Dr. and Leo from the AG's office, Nicola from licensing, and others who've really done a great job. I think it's a good piece of work. Like many of these, it wasn't the easiest to get to where we are, but we got to a really good place. So I recommend it. And with that, I would entertain a motion to approve the memorandum of agreement with the Stillaguamish Tribe of Indians.
I move to approve the adoption of the MOA.
Great. And then I'll second that. Then that is approved. And then if you can just give Dustin the documents, we'll make sure that the board signatures all get attached to that today.
Absolutely.
We'll move that on. Thank you for your good work on it.
Thank you.
Moving along, rulemaking timelines. We'll have Cassidy West, our policy and rules manager, kick us off.
Great,
Ms. West.
thank you. Thanks, Chair Postman, and good morning, Board Member Garrett and members of the public. Well, first of all, congratulations, Marcy. But I'll go ahead and start with cannabis updates today. So we actually, since yesterday, have gotten public comments on the quality control COA expiration date petition. Which is great. So that's going to be presented on the 20th. And we do encourage people to send comments about how this is impacting them or let us know what they think. And we will accept those until the 15th. And just as a reminder, that is to extend the expiration date for the certificate of analysis from 12 to 18 months. And Jeff will be presenting that. We have the THC bill implementation stakeholder engagement sessions coming up. And those will have two sessions that will be the same, and they will be held on tentatively. I'm sending out, not tentatively, I'm going to send out a Gov Delivery message this week that has the date. So December 15th will be the first one, and then we'll do the other one, I think, on the 19th. Sampling, we have I put that on hold for a second so that we could work on the the COA expiration date petition. But I do plan to pick that up after the 20th. So we'll be holding stakeholder engagement for that on conceptual draft rules in January. And then we have another medical cannabis endorsements, and Daniel is going to be working on that. And January 31st is the tentative date for the CR 102. Are there any questions? And I'm going to pass it to Daniel for alcohol updates and for his. Okay, great.
Yeah, no questions at this point. So yeah, why don't we move to alcohol?
Great, thank you.
It's not the first time I've said, let's move to alcohol. Good morning.
Good morning, Chair Postman and Member Garrett. I'm going to be giving a presentation on the alcohol delivery and Mass 13 rule project here shortly, as well as presenting the current petition that we have regarding the beer to go endorsements. The only other alcohol project currently underway is on trade area, and we anticipate filing that 102 January 3rd. We're just waiting to receive some stakeholder feedback following the stakeholder engagement sessions and tribal collaborative rule sessions. And so with the 102 filed on January 3rd, that should put the public hearing, I believe, Valentine's Day, which would then put the 103 at the end of February and the rules in effect by April. If there aren't any questions on that, I can jump into my presentations.
Please go ahead.
Thank you. So this is just a recap of what I discussed yesterday, but the director's office is recommending denying the petition for rulemaking because we don't think that we have the authority to create an endorsement without statutory instruction. And as currently proposed, the endorsement may very well violate current statutes. So on October 9th, Brogan Adams of Cosmic Bottles submitted a petition for rulemaking requesting to create a new rule for what they described as a beer to go endorsement. After conferring with agency staff, I confirmed that licensees that have the takeout and delivery endorsement currently can sell beer to go if it's sold with an accompanying meal and if the other requirements of the alcohol delivery statute are complied with, as well as its accompanying rule. So I clarified that technically licensees are already allowed to do this. The petitioner responded, appreciated my response, but clarified that their petition was requesting to create a beer to go endorsement to allow patrons to take beer to go without having to buy an accompanying meal. So our rulemaking authority extends over endorsements that are created by the legislature that are, identified in statute. The LCB has a lot of endorsements. Almost all of them are in liquor. We have one cannabis endorsement on the medical cannabis endorsement, which I'm doing rulemaking on, coincidentally enough. But every single one of them has statutory authority. Either the legislature says that a certain type of restaurant or tavern is allowed to do this particular activity, or it'll outright say there shall be an endorsement to allow such and such to do such and such. But we have never created our own endorsement without an accompanying statute. And for good reason. It's highly debatable whether we even could do that. Additionally, currently RCW 66-24-400 regarding spirits, beer, and wine restaurants says that while wine bottles can be sold for off-premises consumption, meaning you can buy a wine bottle and take it with you, spirits and beer, you can't do that with those unless it's in a growler or a keg. And in order to do that, you have to have the growler or keg endorsement. If we were to accept this petition and create this endorsement, it would appear to directly conflict with that statute regarding spirits, beer, and wine restaurants. And then lastly, as I'm about to go into regarding the CR 102, alcohol takeout and delivery has very recently been addressed by the legislature. As proposed, this endorsement wouldn't align with that framework. And the legislature hasn't just addressed it once, it also addressed it during the height of the pandemic. And in neither time did the legislature deem to allow for this type of beer to go without an accompanying meal. We circulated this response internally with the agency's divisions, and all of them agreed with our analysis. Therefore, the director's office is recommending denying this petition for rulemaking because we don't have the authority to do what's being asked. Thank you, and I'm happy to answer any questions.
Okay, great. Yeah, I for one agree with the analysis too. I think our hands are tied. It's not, we just don't have a lane there. But as I said yesterday, there's some good questions about why it is the way it is, and happy to talk to people about that if there's a legislative conversation about it. Let me just pause this for 1 second. Okay, great. I'm sorry. Any other questions, comments from the board? No.
No.
Okay, so then we are ready to take a motion to follow the staff recommendation and deny the rules petition to create a beer to go endorsement.
I move that we take the staff recommendation to deny the rule petition.
Great. I'll second that, and that is approved. Thanks, Mr. Jacobs. And now I'm going to ask you to pause for 1 second. I want to go back to Cassidy West for a second.
Thank you.
Yes, go ahead.
Yes, I wanted to mention, and I forgot, the social equity rulemaking timeline will be tentatively holding stakeholder engagement in January. And then the CR 102 is planned, we tentatively plan to file that on April 10th. I also want to mention that we will on Friday, the 7th, is that tomorrow? Yes, the 7th. We'll be holding the cannabinoid science work group. And so people can listen in on that. But we'll also have a recording that you can listen to if you can't make it. But that's it. Thank you. I'll pass back to Daniel.
One quick question for you on the
Yes.
social equity rulemaking timeline, just so you know. So if we do a 102 on April 10th, when do we have a signed, sealed, and delivered product?
Sure. So that would be in July. And I can in July. Yeah, July. Sorry, I'm looking on my computer. I'm having internet issues, so thanks for
That's
the
no
grace
problem.
on that. Yeah.
I am sure we'll have a chance to talk about it again between now and July.
Yeah.
Okay.
Okay, great. Thank you.
All right, thank you. Back to Mr. Jacobs, we will now look at the 102 on 5448 and Mass 13.
Thank you, Chair Postman, and good morning, Chair Postman, Member Garrett, LCB staff, members of the public. This morning, I'm requesting approval of the CR 102 for the combined alcohol delivery takeout and Mass 13 rulemaking. If approved, these proposed rules will be filed today, and there is going to be a public hearing on Wednesday, January 17th. The public have between now and January 17th to submit comments on it. If the public hearing goes forward on January 17th, the 103 will be filed on the 31st, and then that would have rules in effect by March 2nd. The reason that I'm saying if the hearing goes forward on the 17th is because, as you may well know, that's going to be towards the beginning of legislative session. And sometimes there are last minute changes that need to be made where our staff or stakeholders need to be at some sort of legislative hearing or session or something on the Hill. And so if that happens, we'll have to push that out. As brief background, substitute Senate Bill 5448 extended some of the privileges and allowances done during the pandemic for liquor licensees, made some of them permanent, and rescinded others. We filed the CR 101 back in July and held 2 stakeholder engagement sessions in October with some draft rule language. We received comments on the draft rule language from the Washington Wine Institute, and those comments are attached to the CR 102 memo in your materials. The Mass 13 rule project was initiated after the board accepted a petition on a different pandemic allowance, and the petition requested that we make this allowance a permanent part of rule. Just to recap, Mass 13 permit holders are those folks between 18 and just shy of 21 who are allowed to currently pour beer and wine at the customer's table. During the pandemic, the LCB issued an allowance allowing these folks to pour beer and wine away from the table. This allowance expired in September 2022, and after that, a petition was submitted seeking to make this a permanent part of the rule. At the end of most recent legislative session, after Substitute Senate Bill 5448 had been passed, this project, the 5448 rule project, was combined with this Mass 13 project, as they were both on extending COVID allowances. The rule changes that are attached here broadly fall into 5 categories. The first one is adding references to our new alcohol and delivery statute, which is at 66-24-710. distinguishing the endorsements in the new alcohol delivery statute from endorsements and privileges for takeout and delivery that already existed. Ready-to-drink cocktails, consolidating our outdoor service rules, and lastly, Mass 13 rule changes. And so I'll just briefly go over those 5 categories. The first one about adding statutory references is because RCW 6624-710 codified several requirements that in a lot of places were already in the rules. Some of these requirements are such as that a meal has to be sold with alcohol sold for takeout or delivery. Another one is that folks delivering alcohol have to have Mass 12 permits. And these are for people over 21. They're essentially bartending permits. There are other requirements, but those are 2 of the primary ones. Where those requirements were already in rule, we basically just added the phrase as stated in RCW 6624-710. Where it wasn't in rule, we added it in because now that it's in a statute, we also had to add it to rule. The second category is distinguishing the new or newer takeout or delivery privilege from existing takeout and delivery privileges. And this is because 6624-710 identified some licensees, such as distilleries, wineries, and breweries, that already had the ability to sell alcohol for takeout. Like I mentioned in talking about the petition, spirits, beer, wine restaurants were already allowed to sell bottles of wine for takeout. But now, with the new statute, these spirit, beer, wine restaurants could technically, under this new endorsement, do the exact same thing, but they would have to comply with new requirements. So a spirits, beer, wine restaurant that had the new endorsement and wanted to sell a bottle of wine to go would have to sell it with a meal. But if they sold it under their pre-existing authority to sell a bottle of wine, they didn't have to sell it with a meal. This created confusion for staff and for licensees. And so what we did is we did 2 things. Number one, we took out some of the confusing duplicate language, removed some references to some of these licensees so that it was clear if these licensees are doing this activity, they're doing it under one specific endorsement. The second thing we did was we created a new rule, which is in the form of a chart. That's going to be at 314.03.600. And the chart basically addresses 2 questions. Is a meal required? And is third-party delivery allowed? And for those 2 questions, it says it has sort of a chart that on one axis has different types of liquor licensees. And on another axis, it has the endorsement at issue. So it'll say for a spirits, beer, wine restaurant, if you're using the new alcohol delivery endorsement, is a meal required? And it would likely say yes, but it says, but if you're using a different endorsement, a meal isn't required. And it answers those same questions, but for the third-party delivery. This chart was, done as a result of licensing and customer service getting a lot of questions and a lot of internal discussion. So we're hoping that this chart answers questions. But the goal is also not to create new rules via the chart. The chart is really only supposed to be explaining rules or explaining what's already in other rules, but just sort of putting it all in one place. Excuse me. The third category is ready-to-drink cocktails. These have become increasingly popular over the past few years, and they've been the subject of frequent questions to agency staff. Being able to address some of these questions in the context of delivery meant stating specifically that licensees that are allowed to sell spirits for delivery can also sell ready-to-drink cocktails, as well as providing a definition for ready-to-drink cocktails. The fourth category is the outdoor service rules. And so prior to the pandemic, there were a set of outdoor service rules. And then during the pandemic, when the legislature passed 1480, they instructed us to create a set of temporary exceptions to the outdoor service rules to allow restaurants and other licensees that hadn't been able to set up outdoor alcohol areas to do so in order to maximize social distancing and address, this is the time when a lot of places couldn't have people indoors. After a lot of those government restrictions lifted, those rules were very popular And so most recently in 5448, the legislature decided to make what was supposed to be a temporary extension of rules, they made that permanent. And what that ended up with is we had 2 rules that are both permanent and both on outdoor service areas. So as part of this rulemaking, we've tried to combine these 2 rules into one without changing the content. And this last part is important because you may notice that some of the feedback that we got from stakeholders asked us to, while we're combining the rules, to also do some revisions. We've avoided doing that just because we're already doing a lot of changes, and really the purpose of for alcohol and delivery, for combining the outdoor service rules, the point isn't to change the language a whole lot. The point is just to sort of streamline it so that licensees and agency staff have one rule to look at. These are just the proposed rules. So between now and the time the rules are finalized, we may do some tweaks to it. But by and large, we've tried to keep the rule language regarding the outdoor service rules as consistent as possible and sort of kept to what the old language was. The last category is the Mass 13 changes. And so what we've basically done is we've done what the petition asked us. We changed the rule, we've proposing changing the rule language to say that Mass 13 permit holders can now open and pour beer and wine at the customer's table or anywhere that isn't the customer's table, as long as they aren't entering age-restricted areas or going places that folks under 21 aren't supposed to be for longer than necessary. I do want to mention, and I had mentioned briefly, that this rule change is not universally liked within the agency. I mean, I think that's the best way to put it, is that there are parts of the agency and folks within the agency who don't think this is the best idea. They didn't think it was the best idea to accept the petition. It was noted in the petition response. And throughout this process, they haven't changed their mind on it. The concern comes from the concern about increased exposure of alcohol for folks under 21. While these concerns aren't universally held across the agency, it's not everyone in the agency that's concerned about it. Those who have expressed concern continue to express concern, and they don't think that it's necessary at this time, and they're concerned about implementation. While we're nevertheless moving forward with these proposed rule changes, I think I owe it to those folks who remain concerned to make it clear publicly that this isn't something that everyone in the agency is on board with. With that, I'm requesting approval for the CR 102, but I'm going to take a pause, drink some water, and I'm happy to answer any questions.
Great. Yes, that's been a lot. Thank you for the detailed response, and I appreciate, frankly, the transparency of the discussion. The Mass 13 part is the one part I had the most questions about, and I did support, obviously, accepting that petition. I think it's, I guess, and I'll have more opportunity to do this after public hearing and everything else. But, one of the concerns that we've heard from people inside the agency and outside the agency is essentially a slippery slope. If we do this, what's next? Are we loosening these restrictions, and what might that lead to? People younger people be behind the bar even though they're not allowed to. So I do think it's a place where the licensee is going to have increased responsibility, and I hope that we're able to keep communicating that. We are creating, frankly, a little increased flexibility on the one side, but in my mind, with great flexibility comes great, responsibility. So they really need to make sure this is being done in a responsible way. I also understand, part of this has to do with changing labor market, and I, for one, am not interested in continuing to loosen restrictions about young people working in some of these licensed operations for that reason. And so, I think I've always said this about any slippery slope argument. It's up to the keeper of that, right? And it's our responsibility to not let that happen sort of willy-nilly. And I don't think it will happen willy-nilly. So anyhow, with that, other questions or comments on this package?
Yeah.
Okay, sorry. well then let's do it. I will entertain a motion to approve the CR 102 to implement 5448 as well as the Mass 13 permit privileges.
I move that we approve the CR 102.
Great, and I'll second it, then that's approved. Thanks, Mr. Jacobs, appreciate that.
Great, thanks so much.
Yeah, nice work. Okay. I'll take it. This brings us to a public comment period of the meeting. This is where everybody who's already signed up has up to 4 minutes to speak to the board. We ask people to limit their comments to LCB business as much as possible. And of course, refrain from personal attacks or going too far off topic. Ask everybody in the room and online, everybody to be respectful to speakers and those that are listening. We won't stand for any disruptions of the meeting. Reminder to the people in the room, the speakers above you are very sensitive. They'll pick up rustling papers, side conversations, etc. So particularly when people are at the podium speaking, let's make sure we give them our full attention and keep the room as quiet as possible for that. When you're called to speak, we'll give you a minute to connect either remotely or to come to the podium. You'll have 4 minutes. When you're at 3.5 minutes, Dustin will step in and just give you a reminder that you have 30 seconds left. At 4 minutes, we'll ask you to wrap up right away. With that, we'll start with the virtual registrants, and Christopher Kane would be the one.
Christopher King registered to speak, but is not online with us today.
Okay, I know he said he may not make it. We can check back with him when we're done. We'll move then to those that are signed up in person, and the first is Peter Manning.
Good morning, board chairman, postman, board member Ali, and I wish Valendraw a speedy recovery. My name is Peter Manning, president of Black Excellence Cannabis. I have a couple issues I'd like to discuss with the board pertaining to the social equity in cannabis issues that we were having. On September 15th, Black Excellence Cannabis sent out a letter to LCB stating that they felt it was unfair for them to have to do a records request to obtain a social equity score. On September 17th, LCB responded with a letter saying they weren't going to make any corrections, that we would have to continue with a records request in order to obtain the score. This to Black Excellence Cannabis at the time did not seem to be amenable or nor transparent. And so we at Black Excellence Cannabis filed a legal complaint against the LCB. And abruptly, the next day, the LCB made the rubric scores available for the applicants to view. And I think my situation and the situation with Black Excellence Cannabis and our community is, why is it that if we have a legitimate cause or a legitimate concern, we are forced to take drastic actions and be proactive? We are looking for the LCB to be understanding and understand that we have been kept out of an industry for 10 years. There's other entities that have a 10-year head start on the Black and brown community. And we have proven one of the elements behind that was the LCB. Now, I'm not saying that the current members of the board are part of that, but I'm saying that started here. The LCB has been responsible for this, and our community needs to be treated a little bit differently. We do not want to be deemed complainers. We're not complaining about anything. We're asking for fair treatment and equitable treatment. And I don't think that we're getting it. And I'm not very happy that we had to take some type of form of legal action to obtain a rubric score. That made no sense to us. How can you say you're here for the community and you're not doing anything, being transparent with the community? And the LCB continues to hold dialogue about or make decisions about our community, but they don't ever include us in those decisions. And that has to stop as well. We have a right, if you're going to do something for our community, the Black and brown community, it should be transparent. We should be at the table. We should talk about it. You should get the input from our community. You're holding discussions about us without us. And I think as president of Black Excellence Cannabis, we need to shift that. And that's basically all I have to say is just, we need to make some changes. And
Peter, you
I'm
got 30
reaching
seconds.
out to the board today to ask for those considerations to be heard and some action be taken. Thank you.
Next person to sign up is Mike Asai.
Good morning, Chair Postman, Board Member Garrett, and members here in the audience. I just want to give a support for Senator Saldana. We call her Don. She's going through something difficult right now, and just wanted to just say we love her, we support her, and please pray for her and her family. My name is Mike Asai with Black Excellence in Cannabis and also Emerald City Collective. Yesterday, we gave testimony, and I just want to clear something up. If Director Lucella is listening, my comment was not to say the director was a token. The director is brand new here. And for him to be there by himself, talking with House members about the social equity program, I believe was a disservice to him, was a disrespect to him, was a disservice and a disrespect to the Black community. It should have been staff who've been instrumental the past years on social equity should have been there answering questions to the House of Representatives. It's great that there are Blacks that have been hired here at the board, but there's still more changes that need to be made. We see the changes, but there's a lot more that needs to be made than just hiring Black. And nobody here Black is a token whatsoever. Chair Postman, we'd like to have a meeting with you to discuss some issues that we talked with you last year. We need a follow-up. The LCB did not follow state law in 2015. The LCB went rogue when it came to Senate Bill 5052. They gave licenses mainly to white applicants who lied on their incorporations. RCW 43.07.210, it states, filing false statements, penalty. Any person who files a false statement, which he or she knows to be false in the articles of incorporation or any other materials required to be filed with the Secretary of State shall be guilty of a gross misdemeanor. We have multiple that have done that, and this agency knows that. But yet they're still open for business. Look, let's talk, I only got a minute here. So we're solution-based and our complaints are valid. We've been cut out of the industry. For 5080, Senate Bill 5080, here's a brief list of solutions. There was emergency rules for 5052, but there's no emergency rules for Senate Bill 5080. The board needs to look at that. That was in 2016. The board needs to come to the Black and brown community in King County in person to talk about the social equity program, not online, not make green gold. You need staff there. The rubric needs to be prioritized for the cannabis pioneers with cannabis convictions. Former dispensary owners only, no more of this business charter, business plan. It needs to be based on articles of incorporation and the duration of medical cannabis dispensaries up until 2016. Pioneers with cannabis convictions should not have to worry about getting a license. It's which they deserve by their actions, by taking risks and the effects of the war on drugs and living in the DIA. These pioneers with cannabis convictions have to be taken care of first and foremost in order for the future of cannabis in Washington State to move forward in a positive manner. We at Black Excellence in Cannabis want to continue to have positive dialogue with LCB. A lot of Black community leaders did not support Senate Bill 5080. We, as community leaders, did support the agency-led bill because the bill will create generational wealth, many, many future jobs, lives will be changed in a positive manner forever. We can do more and we must do more. Thank you.
I'm gonna just take 4 minutes of my time myself here. I just have to respond to a few quick things. One, I'm glad it was an attempt was made to try to clarify the insulting comment made about our director. By the way, he's been here 6 months, has years of experience in the industry, and is fully leading this agency today on a day-to-day basis.
That wasn't insulting.
And is deeply engaged. And so I appreciate that was
Not insulting.
I appreciate that was clarified, that it wasn't an insult. It's my turn to talk now.
Okay.
Didn't interrupt you. It's absolutely not true that it's been proven that this agency is the problem. There's been investigations, there's been lawsuits. None of them have shown anything. The federal lawsuit was dismissed with prejudice. There's none of that. The claim that that federal lawsuit prompted this agency to put forward social equity legislation is easily shown to be false because the lawsuit was just, the timing is wrong. Go look at the year that legislation came up and when that lawsuit was filed. It just doesn't make any sense. There was not a lawsuit filed over the rubric. There was a change made in the rubric. And one of the problems faced here is that when an issue comes to us from somebody, they may not be the only person that raises that. There are other people involved in this. And sometimes there are oversights. I've said this over and over again in this agency. We actually make mistakes. We are not perfect. Others may be. We are not. And so sometimes people have to come and point something out to us. And what we do well here at the LCB is we correct those mistakes. And I've been told that that in of itself is disrespectful, that we shouldn't make the mistake in the first place and that somehow we don't do that with others. And I'll tell you is that we have far more litigation, far more administrative violation notices, debates, legislative fights, and everything else with the majority owners than we do with social equity applicants. So again, it's just not true. There is not a racist conspiracy at this agency. The work that's been done shows that. And it goes on and on and on. And there are people here who some people don't like and are convinced they work in a racist way. I'm convinced they do not. I think that this board, the 3 members of this board wouldn't stand for that for 1 second. The 3 board members have all been intimately involved with social equity, no more than Member Garrett, but we all have. It's a priority for all of us. We sit in the meetings, we talk with legislators, we talk with our staff. None of us would stand for it for a second. And to believe that that would happen would have to have us either be implicit and involved in this racist conspiracy or dupes. And I'll tell you, none of us are either of those things. And so there may be issues of dispute. There may be problems, and we'll fix those in the way that we always do, in a fair and open process. And sometimes we'll continue to make mistakes. And then sometimes we'll fix them. We pulled down our social equity rules and made them better because of input we got from cannabis pioneers, from people sitting in this room who came to me and talked to me. And I came back and I fought that fight for them. That too, I was told, was an objection because it should have been fixed in the first place. If that were the case, why do we ever have a public hearing? Why do we ever seek input? We have to hear from people. We hear from people all the time of the licensees that exist today in the cannabis realm. In the liquor realm, we had a petition today too. One was rejected, one was accepted. That's how we learn. That's how we do it. We talk to the people who are doing this work and we try to do the right thing. And sometimes when it doesn't work out, we have to go to court. It happens. Sometimes we win and sometimes we lose. We try to stay out of court. And that's my time. And with that, we're adjourned.
There's no rebuttal. I mean, really, but anyway, it's okay.
You know what, Postman, I didn't insult Luke Keller.
No, I said
It
I
was an-
appreciate
it
that
was-
you